Please, Your Lordship. Item number 5, I have filed a progress report by way of affidavit on Saturday only. It may not be on record. Lordship, maybe fixed on day after tomorrow.
So what happened? What about the condition of the road?
A condition of bridge is as per this our affidavit, what we said, it is on the on schedule. On schedule it is.
Not late.
No. Whatever we have last occasion we have given.
Are you in receipt of this affidavit?
Yes, my lord. It says that
Substance?
26.34% is the progress till 31st of May.
No, Lordship,
And
I have
earlier-
photocopies. May I give? Ma'am, I have photocopies of order. Please affidavit, my lord. Your Lordship, please just to allow me to type. Or day after tomorrow, my lord.
Legal and counsel appearing for so and so has submitted that he has already filed an affidavit indicating the progress. Indicating the progress in the project. Full
My
stop. The affidavit be called from the registry and list along with this petition on Thursday,
Wednesday.
Thursday,
Thursday, oblige.
Thursday.
Oblige, my lord. Deep lord.
May please, my lord.
This the first this
Fine.
mention is
My lord, in item 17, my lord.
17, yeah.
My lord, petitioner desires to file a rejoinder to the affidavit filed with the deputy commissioner and circle officer. My lord, 10 days time may be given to file a rejoinder affidavit.
Item number 17, 16 and 17 are the same
My lord,
regarding this constitution of one municipal board.
my lord.
What do you want?
My lord, 10 days time may be given to file affidavit by the petitioner in item 17.
Who is for the this item number 16? Who is appearing?
I don't know, my lord.
R.K. Moore,
My lord.
D. Sharma. It is connected with that, na?
My lord, maybe, my lord. Item number 16.
Yeah.
Gotcha.
You are appearing for?
Lordship for just me.
You are not aware, you are from whom you are appearing.
I was stuck in some other court. My senior was to be here.
Your
He's not.
senior is appearing for whom?
Lordship and
What's the name of your senior?
E. Sharma.
D. Sharma. Here he is, D. Sharma is mentioned as petitioner.
No lordship. For respondent Assam Seat Corporation.
Seeds Corporation, what to do with this Seed Corporation? It's not a matter of Seed Corporation.
Lordship may just allow me some time. The matter may be
Well,
taken
Let the
up.
number comes.
My lord.
My pleasure, Lordship. I beg to mention item number 26 to 30, Lordship. Today I have filed additional affidavit, Lordship. Let it be posted after 1 week, Lordship. Additional affidavit. Additional affidavit.
साथ में लगाने के लिए अर्जुन
Another matter, Lordship. Oh, sorry.
Please, your lordship, I beg to mention item number 37 to 39, your lordship.
Yeah.
This 37 to 39, these are tag matters, lordship. Lordship, my senior Mr. Chaudhary is appearing in item number 38 and 39. So I need an accommodation for today because the assistant counsel he has undergone some surgery in his mouth, lordship. That's why I need an accommodation for today, your lordship. I've taken consent from the appellant from item number 37 also, lordship.
Who is going, who is to be going under surgery?
Lordship, Mr. R.N. Tekar, lordship.
Assisting counsel.
Mr. Chaudhary, in one of the matter, two of the matters, Mr. M.K. Chaudhary is appearing.
Lordship, I've taken consent from them also, lordship.
Arjun,
Much obliged, lordship.
after summer vacation. After summer vacation, ma'am.
My lord, in item 42, my lord.
Yeah,
My lord, the petitioner wants to withdraw the case with the liberty to file a fresh one, my lord.
dismiss with liberty to file fresh. Yes,
My lord.
My pleasure, lordship.
yeah,
With the consent of the other side, lordship, item number 60,
60.
60, lordship. Let it be posted after 3 weeks, lord.
Adjourn after summer vacation.
No, lordship.
Obliged.
With regard to item, my lord, 63 to 67,
Yeah,
the APSC matter, my lord. I have taken the steps and seeking instruction, my lord, with regard to your lordship regarding the legal, my lord, liberal approach, whether that they can be appointed or not, my lord. They are seeking further 15 days time, my lord. And I have taken the
Who is
consent of
appealing
the
for
other side also, my lord. Can it be up after 15 days, my lord?
adjourn summer vacation.
1 minute, 1 minute.
Supposed to file an affidavit, my lord.
67. उसको चार चार को क्वालिफाई कर लिया वही है
That's the matter that civil services
Yes,
matter.
yes, my lord.
We have already fixed. And your stand, otherwise your stand is very clear in the petitions itself.
Can it be after 15 days, my lord?
15 days now,
one week next.
not more than 1 week. Next Monday. Complete your instructions, whatever it may. Next Monday.
May I please, your lordship?
Have you informed the other side?
Yes, yes, yes. In fact,
There are many advocates are.
yes, yes, they have called me up and one is still stuck in their home, my lord, due to the floods with them. So he will be not able to. Yes, your lord.
May I please, your lordship? Lordship, with the consent of other side, I beg to mention item number 52 of today's list. Lordship, the appellant filed an application for condonation of delay, and we need some time to file our affidavit.
Donation of detail.
Yes, lordship.
Item number 52.
Yes, lordship.
There is no idea.
It is already. There is no application for condonation.
Yes,
of
lordship,
delay.
that was also not checked, but they filed it on 31st of May. We got a copy. The application was also not checked today.
I think फाइल करने के बाद ये
Urgent 10 days.
Wait, please. Wait,
Yeah,
wait, please, my lord. I beg to mention item 4. I seek adjournment for the day, my lord. My senior is stuck, my lord, because of waterlogging issue. Item 4, my lord.
urgent after summer vacation.
Fine.
Yes.
Obliged.
Yeah, my lord, I would like to request for listing of the public interest litigation 53 of 23, my lord. It was listed earlier on 23 to 24.
What's the matter about?
Yes, my lord, it is regarding artificial water logging. And it is
Artificial?
artificial water logging, my lord, in the Palasbari area. Because they are constructing bridges, walls in front of the bridges, my lord. Because of that, water is not able to.
Next week. Whatever.
Lordship, I am there for respondent number 7 in item number 17, Kharupetia Municipal Board.
My lord, we are seeking 10 days time to file a rejoinder.
Right, but who is appearing for the, in item number 16, otherwise he'll come and say, yes, some urgency.
Again, I seek.
Yes, Lordship, I am appearing in item number 16, Lordship. On behalf of? I am for the petitioner, Lordship. Petitioner. Now in item number 17, they are seeking 10 days time. Lordship, the methods are different, Lordship. Those are not different. We have challenged this constitution of the municipal code, and they have challenged their inclusion of some of the villages in town. Inclusion of the. Only the same thing, whether the procedure has been followed or not.
Only 10 days time.
More or less the same point is involved.
Lordship. Yes.
He is seeking 10 days, 10 days.
Lordship.
Municipal.
Obliged, Lordship. People obliged.
Daily list for orders item 1 to 3.
Please, Lordship. My Lord, Assistant Labor Commissioner is sending through special messenger today during the course of the day, my Lord.
For moving appropriate application. It's very strange. We are offering you money and you
My
are
Lord,
not taking
because no one was, my Lord, last week, my Lord, there was no one, Lord, no one was holding the post of my Lord Assistant Labor Commissioner. He was transferred and
somebody was holding the charge.
I had talked with him, my Lord, yesterday, my Lord. He said, because my Lord, he do not like to take the responsibility because I am holding
What is
the
the responsibility? We have to take the money and to
My
disperse
Lord, that
this
I
to-
have told him, my Lord. Because of my Lord,
Okay, Learned Counsel appearing for the Assistant Labor Commissioner
in charge.
in charge has submitted that the requisite application shall be filed. Application shall be filed in the submitted that in pursuance to the order dated 15/5/2024. The requisite application shall be filed during the course of the
Right.
day. List on Thursday.
Obliged.
Item 6 to 9.
Item 6 to 9, Lordship, I appear for the petition. Item 6, Lordship, we require some more time, Lordship, to file a affidavit, Lord.
To file a
Rejoin the affidavit, Lord.
which a counter to the writ petition is filed on behalf of the respondents. Consent for the petitioner takes some more time to file counter to the reply filed on behalf of the respondents. List of the summer vacation.
Item 10 and 11.
Service upon the respondent number 4, 5, and 12 is not complete.
Yes, my lord. So my lord waited for service.
Not completed. Okay. As per the name, the service of notice upon the respondent number 4, 5, and 12 is awaited since long. Let fresh notice be issued to the respondent number 4, 5, and 12, registered daily, returnable 3 weeks.
Okay, my lord. Obliged. My lord, item number 11. Item number 11, my lord.
That is the this writ appeal.
Yes, my lord. My lord, at that time, my lord, we have not taken the steps in item number 11, but now as we are taking the steps, so my lord, this appeal may be also admitted.
You
My
have
lord,
taken the steps.
it is same as the item number.
Service complete.
Yes, my lord.
Service is complete on behalf of all the respondents in item number 11.
Yes, my lord.
Let it be, it is tagged with it, we'll hear it at the time of this service of completion of service in respect of this other respondents in writ appeal number 419/2023.
But my lord, the parties are different, my lord. The 4, 5, and 11 of the,
Issue is the same.
yes, issue is the same.
So let the notices served upon in that another appeal. Then we'll consider along with Both the appeals will be taken into consideration after completion of service on all the respondents in both the appeals.
Okay, my lord. Obliged.
Item 12,
Steps not taken in respect of one employee.
आउटस्टेशन काउंसिल लग रहा है तो आउटस्टेशन काउंसिल नहीं देते
कैसे?
नहीं, वो लगता है तो मणिपुर एक पासवर्ड
Password for the time being.
item 13,
May I please, your lordship.
Submitted to the respondent number 2, still the services are not be.
Lordship, already we have taken steps.
Yeah, you've taken the steps, but await return of notice of respondent number 2 for 3 more weeks.
item 14,
में नहीं लिया
May I please, your lordship. My lord, in limitation petition, the respondent number 1 file affidavit in opposition. And I am to file reply, my lord. My lord, so 7 days time may be accommodated, my lord, for me.
37. What about steps on respond numbers 8 and 9? Stuck off.
The notice upon the respondent number 8 and 9 has not been served till date.
It has been stuck off.
My lord, 8 and 9 is struck down.
Struck off. Okay.
Yes,
24.
So what is the ground for condonation of delay?
my lord, that I have explained, your lordship.
In para number?
I'm giving you. In page 7, para number 2, A, B, and C.
Passing of the order. Petitioner, obtain.
वकील कोई
Leonard Single has decided the matter ex parte against you.
No, my lord, caveator was there.
debate was there whether you were
On
party
Mr.
included as
Mr.
party
Mullah.
in that petition or not?
Yes, yes.
Then
He was
what
the
happened?
party and he appeared by way of
Yes.
caveator. And in presence of his counsel, the learned single just passed the order.
If the council has not informed him. what
No.
else?
Basically, he made in this miscase, your lordship, he has taken the plea that the earlier engaged counsel was not informed
He has not informed him.
But it is absolutely false, your lordship, because his counsel, he engaged a counsel as caveator and he appeared before the single judge.
He is admitting that. He is admitting that. He is simply saying that council has not informed him, therefore he was not aware.
337 days, your lordship.
That he explained it that in the August 2023, when he was not paid salary, then he approached that.
Lordship, kindly see para 6, page 9, your lordship. What is it?
Yes,
What he has stated.
yes.
In page 9, para 6. That after knowing about issue, I am reading the
There are 9, yeah.
here. After knowing about issuance of the said letter, the petitioner immediately rushed to Guwahati and meet Mr. Mullah on 8/11/2023. Mr. Mullah means he was the counsel before the single judge. And showed him the letter dated so and so, and then the Mr. Mullah informed the petitioner that challenging the said order dated 10/12/2022, the respondent number 1 filed his petition being WC number so and so in this Honorable High Court. And in the said petition, informed order dated 2/12/2022 was passed by this court. Petitioner asked Mr. Mullah as to why he did not inform the petitioner about the said writ petition and about passing of the said informed order. Mr. Mullah said that the petitioner that he tried to inform the petitioner over telephone, but he was not successful to communicate the petitioner. And thereafter he engaged in his other cases. This is the explanation given. Is it possible, your lordship?
Why not? Suppose he tried to
In
make
absence-
contact with him and once he was not able to make a contact, then.
So my friend ought to have impleaded him, your lordship.
Huh?
My friend ought to have impleaded him.
Completed him party.
Yes.
That would be too much.
In my reply, in my opposition, your lordship, kindly see.
Yeah.
Annexure A, your lordship, see.
Yeah, yeah.
On 5/12/2023, this appeal was filed by the appellant. But on that day, he was present in his duty.
On that day,
On that day, he was present in his duty. So how he filed this appeal?
on his review,
No, this writ petition was filed on 5/12/2023.
appeal,
Yes,
yeah.
but on that day, that means the 5/12/2023, he was in his duty, your lordship.
In his,
He was discharging his duty in his school. So my prayer is that, your lordship, the appellant, your lordship, approach.
do you have a strong case on merits?
Yes,
Then why are you afraid?
but in
In
fact, your
hearing
lordship,
and
in
deciding
the
on merit.
order, whatever, that means the order which was challenged by this appeal, your lordship. In fact, your lordship, in that order, the matter was remanded back to the director.
Fine.
Because in earlier litigation, the matter was
If
remanded
you
back.
have a strong case, why are you afraid? We'll hear it on merit and decide it. The problem. Okay, the matter comes upon for consideration of the application, IN number so and so with the prayer to condone the delay. In condone the delay of 337 days in filing the connected appeal, full stop. And a counsel for the applicant has submitted that as a matter of fact, he has engaged a counsel who appeared for the applicant before the learned single judge at the time of hearing of the writ petition number 7749/2022. However, after decision of the said writ petition on 2/11/2022, the 2/12/2022, the council has not informed The counsel who was engaged by him has not informed him about the said decision. Full stop. The counsel has submitted that as a matter of fact, the appellant had no intention to file the appeal with a delay. However, due to unavoidable circumstances, the appeal could not be filed within time. The net counsel appearing for the respondent number one has vehemently opposed the prayer for condonation of delay and has argued that as a matter of fact, the appellant was aware about the decision impugned and he has failed to satisfactorily explain the delay in filing the connected appeal. Having heard the learned counsel for the parties and after going through the material available on record, we are satisfied that the applicant has sufficiently explained the delay, hence IA number so and so is allowed. Delay in filing the connected appeal, delay of 337 days in filing the connected appeal is condoned. Registry is directed to register the connected appeal and list the same before this court for admission after 2 weeks.
Item 15.
Let me do. In this case, instruction was sought for lordship and my learned friends. Regarding the unabated art cutting, hill cutting in 9th and 10th, my lordship, which is causing artificial flood in Guwahati Lord.
My lord, we have source of instructions. These are still awaited. That apart, my lord, we already have an act in place. And for the forest department, my lords, the area complained of, my lord, doesn't fall categorically whole under area doesn't fall under the forest department. So, my lord, the government has to respond.
I'm going to submit it, furnished an extra copy of lordship. I'm not able to.
In fact,
Lordship,
some of the advocates have mentioned that today also they couldn't come to the court on account of this waterlogging.
yes,
Yes, yes.
That is there, so it's a problem which has to be.
because monsoon has knocked the door,
But
lordship.
what happens, my lord, normally when forest department takes action and blocks these kind of things, my lord, the people approach the high court and they seek, my lord, relief that they want to cut their own earth. Then we have no other business there out there. And normally again, my lord, some vehicles are also running. Some, my lord, modified vehicles. When those are also caught, people again come to court that no, that is my own earth. How can you stop us? That is going on, my lord. That we admit, my lord.
If you have to take action.
Yes, my lord.
And
And there's an already an act, my
The
lord.
people come to the high court will give the relief to them or not, that's another.
There's an act.
You are saying High Court is responsible for waterlogging.
I'm just saying the modus operandi, my lords. Because most of the area complained of.
High Court is granting relief, then your officers is certainly at fault.
No, but the area complaint of is basically within the government managers, not forest areas. We are checking it, managers. So we take remedial measures are taken, managers. For afforestation and the plantations are going on. And there's also Act, managers, 2006 Act.
Ultimately, the response has to be filed by the disaster management department.
Yes.
You are appearing for that. Why you are not filed the?
They have not come up with it.
Yeah,
They haven't furnished an extra copy of lordship.
you are not in talking terms with the advocate. Should have asked her, ask him.
On 28th of April, your lordship notice was issued, your lordship, and extra copies were directed to be furnished.
Should have phoned him. If I am not in receipt of the extra copies, should have sent you immediately.
Yes, your lordship, I should have.
The advocate, why have not furnished the extra?
We have furnished to the government advocate lordship on 2024. And one is to the forest department.
Okay. Response on behalf of the state as well as the respond on behalf of the state of Assam represented through additional chief secretary, principal secretary to the government of Assam, your Chief Executive Officer, Assam State Disaster Management Authority, as well as the Divisional Forest Officer has not been filed till date. Full stop. The petitioner in this PIL petition has raised the issue regarding the waterlogging in the Guwahati city during monsoon season. Full stop. There's notice that the problem of waterlogging in monsoon season in city of Guwahati is not addressed by the authorities concerned in proper manner since a long time. Full stop. The issue is directly related to the public at large. Hence, it is expected that the respondents should file their response within stipulated time, detailing out that what steps have been taken by them to deal with the problem of waterlogging in the Guwahati city. Full stop. Learned counsel appearing for the respondents are granted 10 days time to file counter to the writ petition. Just after 10 days. File your response, whatever it may be. Within
Alright.
10 days.
Item 18.
Lordships, the service report is still awaited as per the office profile.
Respondent number one, who is the respondent number one?
He's the writ petitioner, my lord, in the writ petition, Kamal Dihingia.
Await. Awaiting,
Page 2, my lord.
So fresh note, notice upon the respondent number one is not served since long. Let fresh notice be issued to the respondent number one. Counsel for the appellant is directed to take fresh steps on taking thereafter the notices be issued to the respondent, sole respondent, returnable 3 weeks, registered date.
Obliged, my lord.
Returnable 4 weeks.
Item 19.
My lord, in this case, my friend, Mrs. Arbora is appearing. He's got stuck in a traffic jam. Can it be taken after some time? Item,
Just a minute, it's again for the new steps on this. Neither AD card received nor notice served upon the respondent number 6. Respondent number 16. 19. 19. तो हो गया ना 19 तो भी नाश्ता हो गया नहीं वो 18 था वो 18 था अच्छा 18 नहीं 19 is the steps not taken for service of steps in respect of respondent has not been received by the
but service will be awaited.
steps you have not taken the steps. Where is the question of service?
After some time, my lord. After some-
Counsel appearing for so and so, place a week's time to take steps for service upon the respondent number 6 on from the 16. On taking such steps, let notices be issued to the respondent number 6, registered AD, returnable or so.
Item 20.
Service of notice upon respondent number 6 is
Six is not affected till date.
or can it be taken next week, my lord? As per our information, notice has been received, but
Await return of notice of respondent number 6 for 2 more weeks.
Item 21.
The application.
Sorry, my lord.
Where is the application?
My lord, because of the unavailability of the name lordship, we could not file. But now we have the instruction, we can file. We'll file within 2 days. In
Application.
Yes.
Appeal and counsel appearing for the petitioner pays some more time to implead the necessary party as a respondent. Yes. Let's start with it.
Obliged DPR.
Item 22.
Also, this application has been filed for impleadment of the parties. Earlier incumbent has, one has retired and one has expired. Okay? So the opposite parties 1 and 2 may be considered as respondent number 3 and 4.
Where is the application?
Yes. Interlocutory
This is the
application.
application itself.
Yes.
The matter comes upon for consideration of the application number so and so with a prayer to implead implead what's the name?
Lordship Sri Narayan Kaur. Second,
Shri Narayan Kaur IAS and Srimati Suranjana Senapati ACS as parties respondent number 3 and 4 in the contempt petition number. Contempt case number
536 of 2008.
536 of 2018. Having gone through the contents of the application, we deem it appropriate to, why you want to implead those persons as party?
Lordship, earlier incumbent has been, one has retired and one has expired.
Have you demanded compliance of the order from
Yes,
them?
Lordship, as annexure 2. Lordship.
Page
Page 12 to 15.
this is only addressed to 2 persons,
Yes,
Commissioner and Secretary and Director of Elementary Education,
yes, Lord.
to whom you have already made party.
The new incumbent, Lordship, the commissioner and secretary and the director.
So
of-
why respondent number 3 and 4? This Deepak Gogoi, he has been transferred. Sorry, this Narayan Kaur IAS and Surendra Senapati.
Commissioner, secretary, secondary.
Okay. Then concept of the matter comes upon for consideration of so and so Narayan Kaur IAS and Narayan Kaur IAS Secretary to Government of Assam Higher and School Education Department and Srimati Suranjana Senapati ACS Director of Elementary Education Assam.
Commissioner, elementary.
The secretary.
Narayan Kaur is elementary education or higher in school?
Higher and school. Lord.
Department of School Education one. Higher and Department of School Education.
Secretary so and so.
Yeah, but yeah, elementary.
So,
with a prayer to implead them as party respondent number 3 and 4. It is stated that the earlier secretary to the government of Assam has expired or retired,
Retire. Secretary to the government of Assam has retired, Lordship.
has retired, and director of elementary education has
Has
expired. Stop. Taking into consideration the above facts and circumstances of the case, we deem it appropriate to dispose of this petition with the direction to substitute Shri Narayan Kumar IAS and Shrimati Suranjana Senapati ACS as respondent number 1 and 2 in the contempt petition number 536/2018. Amended cost title be filed within a period of 3 weeks, within a period of 1 week. On filing of the same, let notices be issued to the substituted respondent number 1 and 2, returnable 2 weeks thereafter.
Obliged.
I disposed of.
Item 23.
Service upon respondent number 2, 4 and 5 not complete. You are appearing
I am appearing for 1 and 3, your Lord.
1 and 3. What about 2, 4 and 5? Who are 2, 4 and 5?
am for two, my lord. Two.
You are for 2. What about 4? 4 and 5? 4 and 5, you are appearing. Okay. Mr.
Lordship,
Sonshu
I'm
is appearing on
sorry.
behalf of.
I'm sorry, your Lordship. Perhaps there may be a problem with the petition as it stands currently. Because perhaps what my learned senior counsel says, perhaps the challenges to a rules of the AICT of 2020, your Lordship. But those rules have already been repealed, your Lordship. So if my
Let it be, come on the, at the time of hearing admission, then we'll consider.
very well.
Mr. Sonshu put in evidence on behalf of the respondent number. You are appearing for respondent number 1.
1 and 3.
1 and 3. And Ms. So is appearing on behalf of the respondent number 2, and Mr. Chakravarti is appearing on behalf of the respondent number 4 and 5. Service is therefore complete. Is this the petition for admission after 1 week?
Give your.
Item 24.
So this is a custom appeal under section 130 of the custom law. The appeal is to be admitted on substantial question of law. I placed some suggested substantial question of law. Actually, we are the London CSET didn't consider the materials available before the court. So, Lordship, in my opinion, Lordship, question number 4 and 6.
Where is the include order?
Page 91, Lordship.
What is the perversity?
Lordship, nothing.
There's
has been-
only one question of law, which you have
Yes.
dressed up
Yes, that-
7 or 8 times.
Yes, Lordship, that
Only question is perversity.
perversity.
What is the perversity?
Lordship, may see come to page 93.
Yeah.
Paragraph 5.
Yeah.
After going through the appeal papers, it is seen that the department has conducted the investigation in a very negligent manner. The SCN does not even mention as to whether the statement were recorded in terms of section 108 of the Custom Act, nor or not. The copies of the record statement and panchanamas have been provided to the appellant on a record before the tribunal. Importantly, the so-called notice that was issued, the department has completely ignored the fact that there was second truck bearing number so and so, having lots of 130 bags and rupees so and so was paid to the appellant for the provisional release. No allegation has been made on account of this second consignment in so-called notice. There is nothing on record to show that there has been further so-called notice was issued for second consignment. From the order in original, it is seen that the appellant has been constantly maintaining that the goods were procured from Indian suppliers, and they have properly covered by the GST invoices, even and transactions were properly reflecting the bank statement. the lower authority have not brought any further evidence to rebut the submission of the appellant. Lordship, in show cause notice there is original and as well as in the appellate order.
Two consignments were seized.
Lordship,
Now, in the show cause notice, you have mentioned only about one consignment. Why?
no, Lordship,
And you levied the penalty on both the consignments.
no, Lordship, that may be correct, but Lordship,
May be correct, then what it means?
no, Lordship, Lordship, may please to
That is-
see.
There is non-application of mine. You have not supplied them any
No, no,
statements
that is-
recorded under section
is
108 or whatever it may be.
That is absolutely incorrect, Lordship. May please to see the show cause notice. And there was a reasonable belief. And Lordship, in 1962, Lord Honorable Supreme Court said that it is the department officer, he has to come to a reasonable belief. The London trial court cannot sit over the, because this is, that was, it is the belief of the officer only, Lordship.
Okay, you show us this Kolkata High Court's order. With the, the tribunal has placed reliance.
Yes, one Lordship, that I have not,
Whereas not all.
that I have not brought, but I have brought one Supreme Court.
Brought those orders, it's a High Court order, sir.
Not-
What they have done,
Lordship, may take on Tuesday next time, please.
is plan concept of the applicant, appellant,
Appellant.
raise some time to produce the copies of the order dated 20th of December 2021 passed by the Kolkata High Court in orders number 75842 to 75847/2021 and 75251 of 2021.
It is the order of the CCIT of the Calcutta.
Sir, it is mentioned Kolkata High Court,
Judgment. Lordship, I'll place. Both the
which is
orders.
affirmed by the Kolkata High Court.
I'll place both the orders.
क्या लिखा है notice बताना? Copy of the order passed by the Kolkata High Court whereby it has affirmed the order passed by the tribunal dated 20th of December 2021 in final orders number 75842/75847/2021 and 7521 of 2020.
Much.
Mr. Kyle, there is a difference between grounds of appeal and substantial question of law,
Lordship,
which
yes,
gets
Lordship.
into oblivion once reads this.
Yes, Lordship, that is.
Please correct it. You have put in all grounds and substantial questions of law.
That can't be a substantial question of law. That may be a ground.
That's why-
For two substantial question of law, it's a quite a
that's-
task. You put all the grounds and substantial
Yes, I
questions. of law.
put there. pointed
Now
out,
let me
Lordship,
do the court that you take,
no,
do your
Lordship,
exercise, whatever you want.
No, that's why I pointed out 4 and 6 only.
Sorry, sir.
I'll place and I'll.
क्या आजकल ट्रेंड हो गया है कि सारे बहुत सारे सबमिट कर दो वो तो है बनाया देन यू डोंट गिव इट इट्स द कोर्ट टू फेल इट्स करेक्ट बट देन तो यू डोंट सजेस्ट सपोज
Yes, next.
Item 25,
Thank you.
Appeal by the state, my lord.
Sir Majumdar,
My lord.
whether this division bench judgment was pressed into sentence before the learned single.
Yes, my lord. Lulesa Hazarika was considered, my lord. Lordship would find
Yes.
in the order, my lord, which was
Page?
Lordship would find at page 88, my lord, para 35. One of them was placed, my lord. Bulgari was not placed. Lulesa Hazarika was placed. But thereafter, my lord, two judgments have come, Boikuntha Bulgari and another one. Batsa PR, my lord. These two judgments were also placed in the review. But since it would amount to a rehearing, the matter was not considered and the review was
Two
dismissed.
judgments, which judgments, two judgments?
Lordship will find.
First one is at page 102, my lord.
102.
Yeah, that is of 2012.
Yes, madam.
That is of Badsha,
Lordship will have a page.
Badsha Pyar,
Yes, madam.
And second is at 109.
109.
Yes. Consideration is at page 126 and 127 by the learned single judge in the review. At page 126 and 127. Both completed one of them. Okay.
So this Badsha P judgment, two more judgments are there.
My lord, yes, one is at page 110. That is Boiknato Borgiari, my lord.
That
That-
was also considered by.
That was not perhaps placed before the learned single judgment. At page 110. Relevant portion at page 111.
Yes.
My lord, with regard to both the judgments, my lord, the first judgment, my lord, Badsar Pyar, my lord, both the judgments are actually, my lord, different, my lord. Apart from that, my lord, there are all the facts are not placed before this honorable court, my lord. That's why these judgments are passed, my lord. If lordship may kindly come to, my lord, the notification, my lord, what happened? They are the drop teachers, my lord. Government has come up with a
2 years relaxation, you are seeking relaxation.
yes, my lord.
You have not completed 2 years of
Yes.
service at that relevant time and you were seeking relaxation that since this relief was granted to some other employees, therefore this should also be granted to us.
Yes.
That is, and division bench, similar prayer was rejected.
Yes, but my lord, all the facts are not placed before the division bench, my lord. This is my submission. If lordship may come to my
See
lord.
to now place it before us.
Yes, my lord.
Having heard the learned counsel of the parties, we are of the view that matter requires consideration, hence admit. No need to issue notices, parties are.
My lord, I'm appearing only few of the respondents, my lord.
View of the respondents.
Yes, my lord.
Which view of the respondent?
My lord, respondent number 1, 2, my lord, I will write.
Mr. So and so is appearing on behalf of the respondent number. You please give it in writing, so and so. Let notices be issued to the remaining respondents. Returnable, the respondents requisite to be filed within a period of 10 days. On filing of the same, notices be issued to registered AD, returnable 6 weeks thereafter. In the meantime, effect and operation of the order dated 5/4/2013 passed in writ petition number 6842 of 2010 shall remain stay. Then the Amit Singh shall remain stay.
Obliged.
Item 21.
The repeal is directly against the judgment passed by learned single judge. It is 9/1/2024 lordship. It's whereby the Placeboro University was directed to pay benefit to the petitioner, to the
Your
respondent.
stand is that whatever the amount of pro rata pension,
Yes, lordship.
you will transfer it to the this
Marist.
Itanagar Registrar Northeast Regional Institute Itanagar and they will disperse it.
Yes, lordship.
So what is the formality in that you disperse it?
Yes, no, lordship, that is, no, lordship, but lordship may please to see, page 103, paragraph 22,
Paragraph
paragraph 22, page 103,
22, yeah.
married lordship. His prior service rendered under the central government and the Department of Accounts General Dhanbad School of Mines, now Indian Institute of Technology Dhanbad, would have been ignored and was rightly taken into account by the Tirupati University while calculating the pro rata pension. As the Northeastern Regional Institute of Science and Technology in Usually, Itanagar, Arunachal Pradesh does not have any pensionary scheme. The pensionary benefit required to be paid to the petitioner will have to be paid by the Tirupati University. And lordship further, lordship may come to page 104. He was not
104?
of my appeal, lordship.
Yeah.
This is a letter by the nearest to the Registrar Tejpur University. It's a letter dated 12 September 2019. In reference to above referred letter, the following information is furnished herewith regarding settlement issue of Sri Ashok Singh for payment of pensionary benefit by the Tejpur University due to non-receipt of the approval from the Ministry of HRD Nerist has not been implemented the CCS pension rule 1972 for its employee till date. The service of Sri Ashok Singh, ex-professor Nerist, was terminated during the probation period due to involvement in criminal activity in the campus. Further, the criminal case was registered against him is pending before the honorable court. As such, his terminal benefit cannot be settled from this end till final outcome. So lordship, admittedly, he is not retired from Tejpur University. Earlier he was.
You are right, but your stand is that will not pay him pro rata pension, will only transfer that whatever the amount to the institute and he will disperse it.
Lordship.
What's point in
No, no,
it? You will
Lordship.
transfer it and then they'll disperse it. You're not challenging the claim of the appellant that
No,
he
we
is
are
not
not-
entitled for pro rata pension.
We are not claiming, we are not
So
disputing
you
his.
pay it. What's wrong in
No,
that?
Lordship, further, the direction given by that pensionary benefit should be given by the Tessue University. Admittedly, his service was transferred to Neris and he submitted his technical resignation to the university. So Lordship, after payment of that, he will claim pensionary benefit for a mass loss.
online transfer physically that.
Now they have given all the bank details to us, Lordship. And Lordship, pensionary benefit will be given after retirement. Admittedly, he has not been retired, as reflected from page 104.
You have accepted his resignation.
Yes, Lordship.
Yes, your lien will be.
Then he is entitled to pension. Rule 5,
Page 74,
Rule 5 of the rules.
Lordship, he submitted his technical resignation to the university.
Yes.
So he's not, admittedly, is not my employer.
Sir, you are not disputing whatever is
Yes,
right.
Lordship. Yes, Lordship, that is, we
There
are
is
not,
no dispute about the calculation of amount also.
yes, Lordship. We are agreed by the direction of the learned single judge that pensionary benefit will be given by the test because Neris has no pensionary scheme. Lordship, whether it can be. When he is not retired from our university,
He retired from where?
he did not retire. Lordship, he was.
I have resigned from Tezpur University.
No, Lordship, may please to see page
Yeah,
104.
termination.
Yes,
Yes. On
he
probation
terminated and
period.
case is still pending. That is going on, Lordship. And admittedly, Neris was not made party before the learned single judge also, Lordship.
उसको पेंशन कैसे मिलेगा? He's not retired. धनबाद में था।
If you disperse the amount, so what's the problem in that?
No, Lordship, we have no problem. We are right by the direction of the learned single judge directing the university to pay pensionary benefit. Lordship, suppose we pay the pro rata pension to him directly. Lordship, again, he will come that university is direct to give him pensionary benefit. And further,
Just a
and
minute.
Lordship, further please to see.
We'll ask him to give an affidavit of
Yes.
effect that after getting pro rata pension from the Tezpur University, he'll not claim any further release regarding pension.
That will do.
Yes.
Lordship,
Yes,
Lordship,
I'm ready.
Lordship, further, He,
Because
my
I
learned
figured
senior
because-
said that he resigned from the nearest. That is also probably incorrect. Lordship, page 104 is very clear that his service was terminated and case is pending on.
Either you just show us that on the basis of his termination, all his pensionary benefits are seized or whatever it may be, and he can't be granted any pension, then it's okay, another thing.
No.
But once you are admitting this, he is entitled for pro rata pension, but your case is only that you will not pay this and that institution will pay to it and will transfer it to it.
Yes, Lordship, we have not,
So if he gives this undertaking, that
Lordship-
after receiving this pro rata pension amount from the Tejpur University, he will not raise any claim, further claim regarding any this pension,
Yes, yes.
etc. Then
Yes,
what's the problem? in
no, Lordship, we have no problem.
File an affidavit of this. Because then it concept for the respondent. Has submitted that the respondent is ready to file an affidavit of this effect that once after receiving the pro rata pension amount from the Tejpur University, the respondent will not raise any claim in respect of pension from the Tejpur University.
That's it. Much obliged.
Any claim against Tezpur University, including further statutory benefits.
Will not raise any claim against the Tejpur University for any benefits, including pensionary benefits.
Much obliged.
File this affidavit.
This after 2 weeks.
List after 2 weeks.
After receiving pro rata, once after.
Item 22.
May it please your lordship. May I have your lordship's permission to address your lordships through the virtual mode, my lords?
Yes.
My lords. This writ appeal, my lords, is directed against the order dated 13th May 2024 of the learned single judge, interfering with the selection and appointment of the writ appellant and respondent number 4 after about 9 years of service at the behest of an unsuccessful participant in the selection process, my lords. This is, my lords, the first point. The pursuant to the selection process, this is a grade 4, my lord, junior assistance post in the Golaghat district industry and commercial center in Golaghat, my lords, where pursuant to an advertisement dated 3rd of February 2015, a selection process comprising of written test.
Yes. Continue, please continue.
My lords, my lord, just.
Yes.
My lords, my lord. Pursuant to our advertisement, the selection process comprised of written test comprising of 100 marks, the computer test, typing test. My lords, my lords.
The learned single judge has noted down the irregularities committed.
My lords, I'll deal with that, my lords.
At para number 10.
My lords.
Is this fact is correct that your father was there and he was in receipt of the question paper?
My lord, your lordship may straight away come to page 40. He carried the question paper, but in sealed cover. If your lordship just have a look at page 140, page 140, my lords.
Para number.
Your lordship is right. I am showing the document which authorized him to collect the question paper from the question setter, my lords, at 140, my lords.
Yes, authorization is there.
My lord.
Authorization was there, but is this fact is correct that your...
The fact is correct that his father, my lords.
He was appearing in the examination and
the appellant's father carried the...
And coupled with the fact that you received highest marks in the written examination.
That, my lord, the whole question is, my lord, I received much less marks in interview and the computer typing test. And the petitioner actually received much more than me in the other test. That also shows, my lord, there was no malified intention of the selection committee to favor me.
But
Your lordship is
in fact-
right, my
in fact,
lord.
one of the member of the selection committee has denied that he was not.
No, he has
member of
put
the
his,
selection
my
committee.
lords, his signature is there. But subsequently in a reply, he said that he was not present. But otherwise, the
No,
majority,
he was not even nominated as a member of the
no, my
selection.
lord, that is incorrect because I can show your lordship from the documents itself. May I show your lordship the document in chronology? First, let me deal with, my lords, the allegation pertaining to the written test because that is squarely against me. Because in the
Just a minute.
interview, my lord.
Where is the decision of the Supreme Court where it has been held that writ court would not issue a writ of certiorari unless it can be followed by a writ of mandamus? Where is that? Oh,
Unless I'll check and get back to your lordships.
judgment. Early because it is later. Court will not. So that's absolutely a bad, unless the petitioner has a right, it can be granted. तुमको इस तरह की प्रतिक्रिया नहीं है क्या रोज रीजनिंग एक बात को देखना पड़ेगा. Yeah, Mr. Goswami,
My lords, my lords,
are you aware there are judgments?
my lords.
Have you got these judgments?
My offhand, I don't have my lords.
Next
Otherwise, if your lordships keep it next Monday, I'll address your lordship physically, my lords. I'll be in Guwahati, my lords.
Next Monday.
My lords.
The judgments next Monday.
My lords, may I make a request also for item 62? It's a hearing matter, my lords. I am ready, but if I can address your lordships physically,
61.
my lord, subject to your lordship's convenience.
Monday. 61, okay, Monday.
My lords, deeply obliged, my lord. Deeply obliged.
Item 33.
It is in the interest of public. But really, there's one for the Everybody. देख लो तो वो एंगल से कुछ होता है नहीं तो नहीं दे सकते.
May I please, Your Lordship? Lordship, this writ petition is directed against an order passed by the London Armed Forces Tribunal in original application 38. Lordship, the order of Lordship will find at page 32, wherein Lordship, one of the prayers made by the applicant was to grant disability element of pension with rounding of benefit at the rate 50% to the applicant with effect from the date of discharge. That is 1621. And the learned tribunal at page 41, paragraph 11, has held the impugned order rejecting the applicant's claim for grant of disability element of disability pension are set aside. The first disability of the applicant is held aggravated by army service. The first disability was diabetes type 2, which was diagnosed in 2019, and he retired in 2021. Lordship, in similar matters, Lordship had issued notice. There's in fact
that matters that somewhat different, not exactly covering this.
This rounding off is their lordship. If your lordship will come to page 42, the applicant is entitled to get disability element at 24 for life, which would be rounded off to 50% for life from the next date of retirement.
Here in this segment, now read this para number 8 of the improved judgment.
Yes, lordship.
They have relied upon Union of India versus Ramavtar.
Yes, lordship.
Where the
Now,
court has
there are subsequent decisions of the Honorable Supreme Court, wherein lordship
But notice we should will not grant any, they will after hearing, then will grant this.
lordship, then they will go for an execution, lordship.
Whatever. They will get the notice out at the earliest. Issue notice. The issue notice, requisites be filed within a period of 1 week. On filing of the same registered AD, returnable 3 weeks thereafter.
Prayer for interim will be considered.
Prayer for interim relief would be considered after
On the
notice
next
of
day.
notice upon the respondent.
Also obliged.
Item 34.
Same order.
Lordship, this is round off. Lordship was order staying
That is also round off.
beyond, no, beyond 3 years. Lordship has that from the date of filing of the writ petition, OA, Lordship had allowed that. You have to pay from 3 years from the date of filing of the OA. Beyond that, that will also will adjudicate Lordship.
Was the date of the order of this tribunal?
Lordship, 15/3/2023.
15/3/2023. And OA number?
14 of 2020.
So this respondent will effect from 15/3 shall remain stayed. However, the arrears of the respondent shall be paid to the prior to filing of the OA number 14/2020. Correction. Connect along with those.
Deeply obliged.
Item 35.
Please, my lord. My lord,
Who is for the state? Who is for the state? You are appearing for the state.
Lordship, Mr. D.K. Sharma will appear in the matter, Lordship. Just for some time, Lordship.
Petitioner has raised a grievance that this, as per the direction given by the Honorable Supreme Court, this RTI portal has been started in Judiciary High Court, but not in the state.
Okay.
So what is the present status? Yes.
My lord, I have to take instructions. The matter has come for first time, my lord.
You are in receipt of the copy of the PIL.
Yes, my lord.
You file your response whether pursuant to the direction given by this court, whether this RTI portal is in operation or not.
My lord.
Is functional or not. Look here, Mr. So-and-so appearing on behalf of the All the respondents,
My lord, 1 to 4.
1 to 4. Respondent, where Mr. So-and-so for respondent number 5.
6, 9, 8.
Waste some time to file response to the BIL. Time prayed for is granted. Based on. 3 weeks.
Apply.
Item 26.
Who is appearing for the respondents in this matter?
I'll be appearing for my lord. 8, 9, 10, man.
8, 9, and 10. 6 and 7. What about this? Yes, why you are not releasing the amount? The money was already sanctioned. He has completed his work. Why you are not releasing the amount? From the affidavit of the parties, it appears that everybody is shifting the burden on other side.
Parties.
My lord, your lordship come to page 72 for a moment.
Where?
Page 72.
Page 7,
72, man.
72, judgment.
Yes, my lord.
Yeah,
There are 3, my lord.
yeah.
It appears that from the statements made in the writ petition that the petition has not availed the statutory remedy as prescribed under the section 35 3G5 of the national code.
The simple case of the appellant is that he is a contractor and he has completed a work in the year 2014 for which 19 lakhs rupees were sanctioned. Now there is no dispute regarding that whether he has completed the work or not. It is clear that he has completed the work. Simply is asking, please give me my money.
No, my
And all the departments are shifting, this money was sanctioned. That is also not in dispute, sanctioned but not dispersed. What is this?
In fact, perhaps, I don't know, my lord, in fact, this is a case, my lord, of land compensation arising out of, my lord, the widening of the highways, madam, under the National
This is
Highways
not
Act.
the case of that completion of work. You are not a contractor.
No, my lord.
No, no. In fact, my lord, my land has been acquired.
Sorry, then which is that case?
This is Didar Mirdha, my lord. 36.
Item 36, my lord. Insufficient land acquisition, my lord.
No, no, insufficient.
Insufficient compensation in the land acquisition.
Yeah, insufficient, then you have to.
No, my
go
lord,
to arbitration.
no, not insufficient. What I'm trying to say,
Yes.
my lord, I approach the honorable, my lord, single judge with a prayer saying that, my lord, the award which has been assessed or the amount which has been assessed, my lord, that is not, my lord, first apprised to me. And that is, my lord, released on installment basis. Certain amount has been released, my lord, but a portion of amount, my lord, is lying at the disposal of the competent authority. I submitted representation from time to time. And my lord said that, please release me that amount. Now, I approached the honorable single judge for issuance of a mandamus, my lord, to the respondents, my lord. But the honorable single judge, my lord, observed that, my lord, I have to, my lord, go to the arbitrator. My lord. My submission
No,
is,
arbitrator here is not an arbitrator under 1996 Act. This is an arbitrator under the
Reference.
correct,
NHI.
correct, my lord, under the 1956 Act.
Yes.
My lord, what I'm trying to say, my lord, if there is a dispute, then I have to go to the arbitrator. My lord, here I am not, my lord, raising any dispute. My lord, I am not saying that the assessment which has been made, my lord, is different from my claim. What I'm trying to say before the honorable single judge, that please issue a mandamus
that my amount is not released.
Yeah.
My lord, there is absolutely no dispute.
What was the compensation amount?
My lord, my lord, in fact, yes,
Show
yes.
us. What was the compensation amount?
My lord, the amount, a letter was received, my lord, by the petitioner at page 39, annexer 2.
39.
My lord, page 39. My lord, in respect of the land,
Just a minute, please.
my lord,
Let us go through it. Yeah,
this is, my lord, the translated part is at page 38.
yeah.
My lord, this is S 46, my lord. Now, this amount has been released. Another amount, my lord, is lying, my lord, at the
40
disposal of the competent authority at page
Just a minute,
66,
sir.
my lord.
These 46 lakhs and 74 rupees.
My lord.
This was released.
Release, my lord. And if your lordship comes to 66, my lord.
46 lakhs 0074.
My lord.
That has been released.
Release, my lord.
Then
66, my lord, your lordship will come to page 66.
66.
Yes, my lord. This is addressed to the petitioner. And my lord, the competent authority says that an amount of 47,27,652 is lying, my lord, with the competent authority. Last part your lordship will see, for any claim against acquisition of the aforesaid land parcel, you may approach the competent authority land acquisition Vishwanath district.
Sir, then it means that 40 lakhs have already been released to you and 47 lakhs is something due.
Lying at the disposal of the competent authority.
So you show us that 87 lakh was total compensation, from which document we'll find it.
No, my lord, it is more than 87, my lord. In fact, the
88,
my lord,
89, 90, how much amount compensation?
my lord, the competent authorities, my lord, the PWD, my lord, Industries Department and the my lord, Excise Department, my lord, has made the assessment. And yes, my lord, in terms of that assessment, my lord, it runs to about, my lord, including solatium, it runs to about 4 crores, my lord.
Where is that?
Yes,
assessment?
your lordship will
Where is
kindly.
that determination?
Yes, my lord. I have stated, my lord, in para. I have annexed the documents also, my lord.
So
I have
it
stated.
was,
Yes,
They
yes, my lord.
must have calculated, there must be some order.
Exactly, my lord. Exactly. There are page 40, my lord. This is the assessment made by the PWD department.
Page 40.
40, my lord.
Yes.
32,69,374. And subsequent, my lord, documents, my lord, are the assessments made by them.
It is in your name?
My name, my lord. It is in my name. Didar Midha, my lord. Annexer 3, page 41, it's my name. Didar Midha. Then, my lord, by the Industries Department, my lord, at page 44. This is also in my name, my lord. Page 45, the assessment made by them, 24,96,000. There were small scale industries, my lord.
It is 3,26,000.
32,69,000, my lord.
Yeah, 32,69,000. Yes.
Right.
And thereafter,
Thereafter, my lord, by page 44, it is by the Industries Department. Your lordship will come to the assessment sheet, my lord, at page 45.
yeah,
This is 94,96,000. 24,96,000.
fine.
Yes. And thereafter, my lord. This is a letter. There is another letter, my lord, from the page 60, my lord, by the Government of Assam, Office of the Subdivisional Office, Civil, Vishwanath Charili, Excise Department. It says, my lord, the total estimated cost of the property, liquor establishment, exceeds rupees 2 crore. It's from the Excise Department, SDO, Vishwanath Charili. Dated 9/4, my lord.
It's not clear.
It will be 2019, my lord, or
There is no document. What is the stand of the respondent?
my lord, in fact, the Honorable Single Judge at the Muston stage itself, my lord, closed the matter, my lord. So my submission was, at least, my lord, they should file the affidavit and reflect the stand, my lord.
That is my case, my lord. No, my lord, opportunity was granted to them, it was closed, my lord. And this is not a case of that, my lord. That stage, arbitration, my lord, stage has not arrived yet, my lord. Because the amount which I'm entitled to has not been, my lord, indicated to me.
Seek instruction, my lord.
देखिए, issue notice, Mr. So-and-so put in appearance on behalf of the respondent number
My lord, 8, 9, 10.
8, 9, 10.
For
Mr.
6 and 7.
6 and 7.
Yes.
Is Union of India and NHI, there is a necessity for them, their party to
Yes,
them.
yes, 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 yes.
Standing council name has been shown.
They're required to sign any.
Yes.
In fact, my lord, it is the deputy commissioner, my lord, is the competent authority who, my lord, whose
Money will
affidavit
come
is
from, my
necessary.
lord, National Highway Authority of India.
That will come from there, my lord. But NHI DCL has a, my lord, standing council, my lord. 2, 3, my lord, 4, they have standing council, my lord, and copy has been served to them. Their name has also been shown in the cause list, my lord.
Who is the concept?
Mr. C. Barua,
Yes, my
My lord.
can you please call
Yes,
him? The CGSE will take for 1 and C. Barua for 2 to 5.
I'll inform him, lordship may record the, my lord.
Okay, issue notice. Mr. Senior government concept name.
C. CGC Mr. RK, RK D. Chaudhary for respondent number 1.
The C Barua for respondent number 2, 3 and 4.
2 to 5.
2 to 5. Mr.
Miss N. Bordelais for 6 and 7.
N. Bordelais for 6
And
and 7.
Mr. And thus.
8, 9, 10.
8, 9, 10. Services therefore complete. The concept of the respondents may file their response within a period of 4 weeks. Within a period of 6 weeks. After 6 weeks. Check.
Obligation.
Item 40.
Oh, it matter.
May I please, your lordship? My lord, the matter was already admitted by the order dated 8/5/2023, Lord.
This appeal itself.
Yes, lordship. And post-admission, lordship, we have already taken steps upon the respondent number 7, lordship, which was served
Is
properly.
already admitted. It is noticed that the appeal was admitted on 8/5/2023. Hence, list this appeal for hearing in due course.
Who is appearing for respondent number 7?
Lordship, no one present.
Then apparent.
2 times notice served upon him, our lord. Post-admission and pre-admission, lord. But she could not appear, lord.
No, but the 24th April office note says neither ID card received from respondent number 7 nor.
Lordship, on last order, lordship, on 12/4/2023, initially notice was served, lordship.
Yeah.
Pre-admission, lord.
Already admitted, same order.
Obliged.
Item 41.
May it please your lordships. Lordships, by the last order, the respondents were supposed to seek instruction on paragraph 5 of the additional affidavit filed on 10th of May 2024. The quantity of formaldehyde was incorrectly mentioned in the affidavit.
Just a.
আপনারা করে
There's no allegation that is directly in the plan. So, do we?
Madam, now this issue regarding this contaminated fish and all, that has already been raised before the Green Tribunal. And on 9/4/2024, the Green Tribunal, after taking into consideration the standard operating procedure published by the government in January 2024, has taken note of it and said, he already issued a direction to strictly follow that standard operating procedure. What remains in this petition then?
Lordship, the scope of NGT in my humble submission is with regard to the environmental aspect.
Ma'am, this is the order, whether this
Lord,
order is
I
under
will
challenge or not. This is
Lordship,
the
I will,
direction.
I will check the order. I'll search it
This is
on.
the order, you go through it. This issue has been dealt with in detail by the NGT and they have already issued a direction. The same issue.
But my lord, in the latest affidavit which has been filed by the state respondents, it has nowhere been
There's some
shown.
discrepancy which he.
Not only that, my lord, apart from that, yes, my lord, the SOP needs to be followed strictly. That has been held by NGT. But the steps which have been taken after implementation of the SOP, none of the certificates from the vendors or anything has been annexed to the additional affidavit file.
This petition is going on since 2020.
My lord, more than
This
one.
is the latest judgment of the NGT. When comprehensively dealt with the matter and they have already issued directions.
To conform to the SOP and follow the same.
Yes.
In my humble submission, my lord, the SOP contains a particular guideline which says that when the fish is being imported in the state of Assam, there has to be a certification with regard to the amount of formaldehyde used or not used at all. But in the latest affidavit which has been filed on 10th of May 2024, no such certificate has been enclosed, which shows that the SOP is not being strictly followed. And if your lordships recollect, this particular direction to file the additional affidavit was passed by your lordships after taking into consideration this order passed by the Honorable NGT.
On that day, we were not aware of this order. This order today only, this order came to our notice. On that day, this order was not before. On that day, this order
No,
was not. correct.
As far as my knowledge goes, my lord, this order was placed before this honorable court and then your lordship had
Maybe
specifically
it was
raised
placed, but we have not gone through that order at that time.
possibly,
It
my
was, it was. Mr. Bansal, you were supposed to file an additional affidavit clarifying the mistake which you.
Yes, lordship had asked me to seek instructions on this issue. The additional affidavit was filed.
Clarification.
Yes, on that issue, your lordship, two things were specified in the additional affidavit which was objected to by the petitioner. One, that it was regarding the level of formaldehyde in freshwater fish and marine fish. Now, originally, in the year 2019, your lordship, the FSSI had issued a draft notification wherein freshwater fish, all categories, the level of formaldehyde was fixed at 4 mg per kilogram. In the affidavit, there was a typographical error, your lordship. Instead of 4.0, it was typed as 40, your lordship. That is one mistake made in the affidavit, typographical error. It should be 4.0 and we stand by it. Now, regarding the level of formaldehyde in marine fish, your lordship, though in Assam, the fish markets hardly stock marine fish, your lordship. It's almost 100% of it is freshwater fish, your lordship. But since the issue was raised in marine fish, initially across all categories, it was fixed at 100 mg per kilogram. Then in 2020, your lordship, it was revised and marine fish were categorized into two separate categories, your lordship. And across those two categories, for a few specific categories, it was fixed at 4.0 and 8.0 for those specific species of fish only, your lordship. So as far as now the position is, your lordship, apart from those categories which are specified as 100 mg in 2020, for all other 8 mg in 2020, for all other categories of marine fish, it is 100 mg, your lordship, per kilogram. So the affidavit is correct. Apart from that, 4.0 and 40 is a typographical error, but otherwise it is.
So
correct.
how do we know that even this 10 mg, 8 mg, whatever you're saying, that is within the acceptable limit?
Because that is what has been fixed by the FSSI. The document is on record.
It's on record, my lord, page 87. Running page 87. It is an affidavit filed by the interveners, the Andhra Pradesh Fish Association. And it encloses the amendment regulations of 2020.
Yes.
And marine fish are into two categories. The first category is 8.0 mg per kg. And the second category is 4.0 mg per kg. But the affidavit says 100 mg per kg.
This is the original notification of the FSSI, where without differentiating marine fish into different species, your lordship, across all species, it was fixed at 100 originally. Then for these particular species, your lordship, it was brought down to 4 and 8. So, but regardless of whatever is the level fixed by FSSI, tomorrow they may revise it again. We'll have to go by it, your lordship. We are committed to following whatever is fixed by the FSSI.
Since last year till now, this is the limit.
That is the dog limit.
Yes,
Maximum limit, ma'am.
Yeah.
That is the maximum limit is 8.0.
Following an ad hoc limit of naturally occurring till assessment is done.
Yes, so
till date, no assessment is further.
fine. Then what they have done, your lordship will see this, they have made a general category across all marine fishes. In this second notification of 2020, they have only classified a few particular species of marine fish, and across those fish, the formaldehyde levels have been fixed at 4 and 8, your lordship. So for those particular species, your lordship, we are committed to ensuring that the levels of naturally occurring formaldehyde does not cross that level. And for other species which is not in that list, it will perhaps be 100 as per our understanding. And for freshwater, there is no discrepancy. In both the notifications, it's 4.0.
Your last affidavit was filed on 10th of May.
10th of May.
And there is an order of 13th May.
There is an order of 13 May asking me to seek, get instructions on this issue, Your Lordship.
No,
And the
Yesterday, I'll
report,
bring it on record by way of an affidavit.
and secondly, my lord, as per this affidavit of 10th May, it states that samples of fish have been sent to independent institutes, one in Assam and the other one in Kerala. So the reports from those institutes are also awaited.
Yes,
place
we had,
those reports.
yes, we had done that because so that the public should be assured that the fish that they are consuming, Your Lordship, it is safe. That is
Alright,
the
so
ultimate.
come up with the transparency.
Very
You produce the reports.
It will take some, the reports will perhaps take some time, Your Lordship, because though they have been sent, we can place both the reports together, maybe 3 weeks time, Your Lordship, for the report. And otherwise, if Your Lordship desires, I can bring this also on record.
See, the idea is, since the alarm bell is raised on public health
Yes,
issue,
sir.
we can't be hyper
Yes, sir.
technical on these matters.
Fish, Your Lordship, it's one of the most common sources of protein in Assam.
The concept of the respondent number 3, they submitted that the reports from the Central Indian Fisheries Research Institute, any reason at Guwahati, and Central Institute of Fishery Technology at Cochin, Kerala, have not been received yet. He placed 3 weeks time to submit those reports before this court by way of an additional affidavit, wherein wherein it should also be explained that what the action has been taken by the respondents in relation to the action has been taken pursuant to the SOP dated, that is SOP is dated 20th of
January 2024.
January 2024.
On that aspect, the affidavit is already on record.
You have already filed
On 10th, the
Yes.
affidavit of 10th of May specifies that.
the report. What's the matter? No. The उससे ऊपर का no, that additional affidavit, time period for is granted, list of 2 weeks. Very, very.
Obliged. Deeply.
Item 43 and 44.
Your Lordship may kindly be pleased to produce the last order, Your Lordship, dated 8/5/2024.
Yeah, they are seeking time.
My lord, we have to bring about a modification in the recruitment. rules, my
Inserting
lord.
promotion.
My lord, the model code of conduct going on as of today, my lord, we have not been able to place it before the cabinet. I'll require 2 more weeks. I'll require 2 more weeks, my lord. It's not been placed before the cabinet as of.
Mr. Majumdar, raise some more time to do the needful as observed by this court in the order sheet dated 8/5/2024. List after 3 weeks.
Obliged. Much obliged.
Item 45.
Please, Lordship. My Lord, this case file issuing notice, your Lordship was pleased to stay operation of the judgment, single judge, my Lord. Well, I understand that your Lordship may like to admit this and not.
Admitted on here. Yes. My lord, the charge, my lord, that has been leveled against me, my lord, is excess of 320 weight bags, my lord, of weight, my lord. Coupled with the allegation that you measured the, this wheat, in less quantity. And therefore this excess 340 bags were there. My lord, the 320 excess bag, my lord, that has not been caused any pecuniary loss to the department, my lord. That is, my lord, and it is not a misconduct, my lord. Let us see. My lord. Having heard the learned concept of the parties, we are of the view that matter requires consideration. Admit. No need to issue notice as parties are already represented. List this matter for hearing in the month of August. List this appeal for hearing in the month of August 2024. The interim order passed by this court, by order dated 20th of March 2024, is made absolute.
Item 46.
Lordship, in this case, on the last occasion, your Lordship was directed to.
Lordship,
file
I am
an
receiving
affidavit.
the signed copy of the affidavit today itself, Lordship. I am filing with today.
This is regarding that affair.
Yeah, you're filing affidavit today,
Today I am receiving the signed copy.
Friday,
Lordship.
Friday, this time Friday.
My lord, it is that matter where we inadvertently quoted 2,01,000 instead of 20,001. Some mercy can be shown by my learned friend also, my lord.
That is for, learned call.
Let them deduct some cost on account of holding the second auction. So that for each action, the corporation has suffered a huge amount, my lord. To the extent of rupees more than 27 lakhs, my lord.
How much amount?
That's right.
You incurred in that second auction? The auction, how
There's
much
a
amount?
difference between the bid amount offered by law firm, my lord, and the present with whom the sale has been confirmed, my lord. That's for that actually taking for 3 My lord, actually, the consignment was sold, there was no reserve price. It's not that any reserve price was fixed, that they have to sell it or auction it at a price less than the reserve price. Some administrative charges.
Mr. Das,
No,
my lord is saying 20 lakh mein nakki karo.
No.
What is your response to that?
My lord. Actually, I'm sorry, my lord. The amount figured out here is I placed before, my lord, that was not correct, my lord.
Absolutely not correct.
No.
But,
Not even 36 lakh.
20 lakhs is, a good handsome amount, sir.
No.
Ultimately, you suffered a loss of 27 lakhs.
No, my lord. Actually, more than a crore, my lord. More than actually a crore, my lord.
They are calculating the loss, my lord, quoting my figure of 2,01,000.
That is fine.
4.1 crore, my lord.
That's another thing, sir. He has quoted price, but what was the cost you incurred on the re-auction?
Yes,
That process.
that actually we have not charged anything, my lord. Only the difference of a price, my lord. That way, my lord.
Too
There's a the difference
Too
of
harsh.
big amount, my lord.
Sir, too
Ultimately,
harsh.
for him, we have the corporation have to suffer, my lord, to the extent of more than 4 crores, my lord. Let them pay that amount, my lord, in that case, my lord. Because re-auction, or his my action, my lord. The corporation has to go for by.
He approached the court against your action of forfeiting 34 lakhs and you are
Hello.
saying pay 4 crore.
Hello.
He's aggrieved by this. Forfeiture of earnest money, money that is of 34 lakhs.
No, money, that money, so his action, my lord, that will be belied by his own action, my lord. From the letter which I am going to place before a lordship, my lord. Before putting in the system, my lord, the amount of offered by him was confirmed, my lord. And after confirmation, my lord, the figure was put up in the system, my lord. Once the matter is, the figure is entered in the system, lord, there cannot be any sense, my lord. There is a stand of the corporation, my lord.
Mr. Consul, you have some consulted with your officers.
Yes, but from him, that's it was confirmed, my lord. Before entering the figure in the system, my lord. Once he has confirmed. Yes. That is the reply given by the testimony of formal.
Mr. Das, just 1 minute. You see, if your projection is this, that had the 2 lakh odd rupees quoted by him used to settle this deal, then you would have gained so much. So therefore, since he has backed out, so that is a loss. That is, we are sorry to say, this is totally unacceptable argument. That is incorrect and we are rejecting that. The question is, he did make a mistake. Whether it was an intentional mistake or an unintentional mistake, that is a different matter. The petitioner did make a mistake. He quoted a higher amount and then according to him, he had withdrawn from that bid in so far as the amount is concerned, but that is in dispute. But the fact remains that the corporation did suffer some inconvenience. It had to retender, which would involve some cost, some delay in the matter. So we are asking you that taking an equitable approach, can this matter not be sorted out in somewhere in the middle? For nothing, he would also lose a lot of money. So it is not that he is going scot-free. We are not exonerating him. If we have to deliver a judgment, it could be either 34 lakhs will be maintained or it will be 0. Either ways. Either we allow the writ appeal completely or we dismiss it. Instead of doing that, we are thinking whether a more equitable approach would be a better way in these matters, because sometimes the writ court has to also wear the hat of equity. What is your response to that? Your corporation definitely did not suffer 4 crores. That kind of a loss is not acceptable. What money you would have made, that's not a loss. Because it is his projection that he did it out of some miscalculation or misquoting or whatever it is, which could be, as I have mentioned, which could be intentional, unintentional. Let us leave it at that. But he did make an attempt to retrieve the situation. Maybe it was 5 minutes too late or 10 minutes too late. That is another matter. But there was an attempt to recover. There was an attempt to retrieve. He did not succeed. Okay. We are not saying the corporation did anything wrong. But now that the matter is before the court, the writ court is asking this question that can a middle path be explored in this so that corporation also gets some suitable compensation and he also pays a price for his mistake. The mistake is costly, there is no doubt about it.
Right.
He's a contractor, he's been repeatedly bidding. So,
Regular contractor.
so if he has made a mistake, he has to pay the price. The question is how much? Mr. Chaudhary is saying we are ready to compensate to some extent, but 34 is too much. You are saying 4 crores, which is not acceptable. 4 crores is not the loss, certainly not the loss. It's not your demand. So
No, only different.
can you not get a little better instruction on that? Otherwise, we'll close the matter and deliver a judgment, which is either we allow the writ appeal where you get nothing, or we dismiss it where you get 34 lakhs. That will be the only option left to us. If we have to write a judgment, we have to go by legal principles. Why don't you talk to your clients and
My lord, I may give him some time so that I may have some conversation with my client, my lord.
written instruction. Mr. Chaudhary, 20 lakhs.
Deducted or we'll get back, my lord.
No, 20 lakhs.
36 lakhs and 61,000.
34. They have already deducted.
They have taken the.
They have already allocated. Already forfeited, my lord. We have already forfeited.
We have already done.
Because that is the terms of
Okay,
the.
refund.
My lord.
Refund of amount of, you, will allow them to deduct 20,000, 20 lakhs and remaining amount will be refunded. Or you take your instruction.
My lord, can I have some time, my lord? So just so that.
Yeah, certainly. Fine. Yeah. Consider appearing for the, Mr. Ensida, senior advocate, appearing for the respondents, appearing for the PGCIL. Waste some time to complete his instructions whether the PGCIL is ready to accept, ready to ready for an amicable settlement regarding the amicable settlement of the dispute. List on
Let it be after 10 days, my lord.
10 days. 10 days. List on 12th of June.
Item 48.
May it please your lordship. But I believe in this matter, I had a word with the council in the morning. The names of the departmental council were not indicated. Perhaps they're not appealing for that. But for the present, no promotion has not been effected, my lord. It was that matter where forest girls were promoted to the post of forester grade 1, my lord. Subsequently, promotion order was kept in abeyance, thereafter cancelled. In a challenge to the jurisdiction, my lord, the honorable court held. Single judge was pleased to hold that.
First comply with the order and then come.
Absolutely, comply and come.
Who is for the?
नाम नहीं लिखा है सर.
The names were not indicated.
Look here. List this matter after a week while showing name of Mr. D. Gogoi as counsel for the respondent forest department.
The interim protection needs to be extended, my lord. That no action be taken on the notices.
Interim order passed by this court on 1/5/2024 shall remain in currency till next day.
Item 49 and 50.
Decision we have some say in the way to as you need for.
So there is a.
Well, there is a recent development, my lord, where the government has given that copy, my lord. where government itself has taken a decision to pay pay to equal workers. That circle one. itu dulu instruction kan dari yang ini. Hah? Kopi kita mungkin nak. Itu kenapa? Kamu apa?
By what time they are going to?
Well, Lord, I think possibly my learned friend will have to take the instruction. If this is what happens, then our grievance should be redressed.
Well, then in that case, well, a week's time.
Committee recommendation is already there.
Well, that I am not aware, madam, because it has not been brought into record by an affidavit. But if a copy is given to me, I
It's
can.
a decision of 15th of March.
Decision one.
They signed it.
Okay, Mr. So there's some time to complete this matter regarding the cabinet decision dated 15/3/2024, wherein the government of Assam has decided to follow one pay for one for same and similar post policy. Just after 2 weeks.
Complete instruction.
Item 51.
4 weeks. 4 weeks.
My lord, here, my lord, the impleaded respondent eight. My lord, impleaded respondent eight has filed an affidavit. And in that affidavit, in paragraph number 6, my lord. Your lordship will kindly see paragraph.
Paragraph 6.
Yes. May I read it, my lord? That in
This
this,
affidavit dated
my lord,
13th May.
they have, my lord, the Hill Area Department, parent department has given the fund to the principal secretary of the North Kasar Hills, my lord. So I am the contractor under North Kasar Hill. So what the paragraph 6 say is that
Paragraph 6 of what?
respondent 8 affidavit.
Respondent 8 affidavit.
Yes, in opposition. Page 110, my lord. May I read it, my lord?
Yes.
Now this, my lord, it stated that in this connection, information on Hill Area Development Program scheme is sought from Development Commissioner for Hill Areas, Assam. Information received from Office of the Development Commissioner of Hill Areas, Assam, that rupees 6693.30 lakh was released to both Karbi Anglong Autonomous Council and NC Hills Autonomous Council as first installment, including the matching state share during 2014-15 under HADP. It may also be stated that both KAAC and NCHAC submitted their respective utilization certificates against the aforesaid release amount, which were also forwarded to NITU Ayog. Now, my lord, the petitioner contractor has not received the amount. Although the fund was given to the NC Hills and they have utilized, my lord, and they have also submitted the system, but it was not paid to the petitioner appellant, my lord.
Who is depending for the NCLs? Why you not paid the money?
For last 10 years, my lord, they have not paid.
2014 money is due. What instructions? This, you are appealing for the first time?
In petition, lordship, we have stated in our affidavit that it is a time-bound project. Since the petitioner has failed to complete the work, that's why we have returned.
This is not even dispute that he has failed to complete the work. It is the case of the other respondents that he has completed the work within time.
Lordship.
Within time, he has completed the work.
No, not
Yes.
In our affidavit in operating file in the before the single bench, single judge, lordship, we have stated that fact.
So since he has taken longer than what was required, so you'll not pay him.
That is not the case, lordship. Lordship, what we have stated in our affidavit, that this is a time-bound project. The project was a time-bound project, 90 days validity time was there. Since he has completed the work after 90 days, expiry of the 90 days, so the amount has been refunded to the state court.
So the learned single judge has issued a direction to consider his claim and examine the claim of the petitioner within 45 days and from the receipt of the and do the needful. Whether you have challenged this order, you have filed an appeal against this order, then whether you have complied with the order of the learned single judge or not, whether his claim was considered at all or examined or not. Why? Why you have not examined that order?
No, we have examined that order, lordship.
Where is that order rejection that he is not entitled for any money? Where is that?
He is entitled for the money, lordship, but he has failed to complete the work within the time-bound.
So whether he is entitled for any money or not,
For that, lordship, we have already raised a supplementary demand to the state government, lordship, since we have refunded the amount to the state government.
We'll call the officer then, let him come.
Yes.
You are not giving convincing replies. Who is the officer?
Lordship, can kindly give me a week time.
Yes, you get 1 hour's time at 2. Yes.
at two, complete your instructions.
Lordship.
Some money is due, whatever the money, you just come out with this money is due and we are going to pay him that money. 2014, the work was already completed.
Okay.
The learned single judge observed this in this order that the work has admitted contract work has already been completed. Total value of the work is 19.9 lakh and he is entitled for that money. 2014, he is waiting for that.
And also give us the name of the officer who should be summoned to the court.
Who are the respondent number 2 and 3?
Yes, madam, 2 and 3.
You are for?
Lordship, I'm for the NC's autonomous council.
He is appearing for 2 and 3, madam.
2 and 3?
Yes.
Will issue a contempt notice. If you are not complied with this order and not examined this claim, we are going to issue a complete your instructions by 2. Complete your instructions.
Lordship, as per the telephonic instructions which I have received from the principal secretary and autonomous council.
So loud, please speak.
Lordship, as per the telephonic instructions which I have received from the principal secretary and autonomous council, payment will be released to the petitioner within 2 months. Lordship.
Within 2 months.
Lordship.
The whole file an affidavit.
Lordship, I will.
Then a council for the NC Health Autonomous Council.
Lordship.
NC Health Autonomous Council, Mr. So and so. Place a week's time to file an affidavit that the due amount will be paid to the appellant within a period of 2 months. List on next Tuesday.
Item 53.
My pleasure, Lordship. Lordship, my senior Mr. S.K. Mehdi is on list in another court. Kindly matter may be passed over for some time being.
There is no urgency. There is no urgency in this case.
I have been discharged. It can be taken up another date also, my lord, subject to.
Password for the day. pass over for the,
May I pray for a date, my lord?
pass over for the day, then it will come day after. Like.
Pass over matter 12.
Right. After a week, then present even in second round, after a week.
Item 54 to 57.
So for item 54 is concerned, Lordship, there were some pending affidavits we have already filed it on behalf of the BTC also, as well as from the remaining districts of the state of Assam. So we are furnishing the copy to them, let them respond to it, Lordship.
Lordship.
In
In item number 54 PIL, your lordship, there is a, in fact,
yes,
This PIL is for what?
your lordship, this was for your lordship, making the tribal belt and blocks your lordship encroachment free. In fact, there is a direction passed by this honorable court already, your lordship, and they were supposed to, your lordship, government was supposed to furnish the present position, your lordship, how much amount of land has been, your lordship, cleared from encroachment, etc. That has not been come, your lordship. I will respond to that affidavit, your lordship. In fact, the data that have.
Earlier order was of 3rd of February 2021.
Lordship. In terms of that order, what action they have taken, your lordship, the government has taken, your lordship.
They have filed affidavit.
They have filed an affidavit. I will respond to that, your lordship, so far as the PIL is concerned. The connected matter is, your lordship.
Affidavit is filed on behalf of the state
as well as BTC, Lordship.
as well as
Bodoland Territorial Region,
BTC,
BTC.
detailing out the measures carried out by the state government for measures carried out for the purpose of removing encroachment, but we can't say encroachment.
Yes. Removing the persons who are not protected.
We are giving the data, Lordship. Basically, the initial stage was that.
Tribal belt.
Regarding the status.
The carrying out the efforts carried out by the state government to restore the land to the.
Lordship, that may not be the correct statement from my side. We have given the complete data regarding what are the areas in tribal belt and blocks encroached by some of the persons who do not belong to that category. The figures we are giving.
Detailing of the measures carried out to free the land protected for the tribals encroached by the non-tribals.
And who are not protected class.
Encroached by the illegally encroached by the non-tribals, which is not who are not belonging to the protected class. Full stop. Then it concept for the petitioner takes some time to respond to the affidavit filed on behalf of the state and the BTC. List after, yes, okay, and the connected matters.
My lord, we are also in this case item number 54. We are representing my lord respondent number 13 to 27. We need to file a copy of the affidavit may be signed out.
Okay, and what about this connected matters?
Lordship, item number 57, Lordship. 57 is also, Lordship, similar, Lordship, grievances we have. So we are original patadars of that area, Lordship. So our lands have been also encroached upon by after when the ethnic clash happened in 2012. So we are displaced, then we have gone there, then our lands were not there. So like no affidavit has been filed in this matter. Also, an affidavit can be filed.
So far as this item, in my humble submission, it may be segregated from the case.
Why?
Because that is a isolated case.
Okay.
Just one second, just. General tribal
It may go to the learned single judge also, Lordship, this matter.
Yes, and 55 and 56.
I try to appear for the respondent.
Who is for the petitioner?
57 Lordship, I'm for the petition.
57. What
So,
about
so
55
their
and-
Lordship on affidavit maybe.
55 and 56.
Mr. Chaudhary.
What's the matter about?
Yeah, like.
Item to do, amount to 56. My lord, this petition has been filed by us, where we have challenged an order of the Assam Board of Revenue. But because they also, my lord, it pertains to alleged encroachment of tribal belt and block land, therefore this matter was also tagged. That is how the matter is before us.
Don't think so. These matters are this item number 56 and 57 are to be taken separately.
It can be.
Because these are decided cases, my lord, there's a order,
can be, my lord.
order of the deputy commissioner affirmed by the board of revenue.
Whatever the rights have already been adjudicated. And
Yes,
we
but
have
that's been
to-
adjudicated and held, my lords, that my learned friend's client, my lord, is not entitled to that land.
Then what about this 55? 55, Mr. Who's appearing? Barguria. Barguria.
Matter can go to single judge.
And Barguria.
Mhm.
55.
My lord, if I may point out, because this matter was tagged with the batch, that's why it came before DB. Otherwise, my lord, as against the order of Board of Revenue, matter lies before the learned single judge.
Okay, they will make a mention of this.
My lord, in this matter, my lord, Board of Revenue order was not challenged today. Second thing is that, my lord, it was tagged.
So even though if it is not challenged, whether this matter is to be heard by the
Has to be
division
heard by-
bench? Whether this matter is to be heard by the division bench?
Single judge. I tagged because my lord, division bench order is contradictory to the order passed by single. One side division bench has said, honorable division bench has said, you evict this person, otherwise we take the salary from the people. And the single judge by law, interim order has been passed. I think we'll take.
You can very well apprise the single judge.
Okay,
This
just-
item number 55 PIL.
Mitch, what is the issue in item 55?
Heritage, motor vehicle was established there. That also falls under the tribal. So he wants protection. I do not know who appeared in this case, but or maybe senior counsel and doctor appeared at one point of time. In that Amsang area, there is a one heritage center where all the past old including
Vintage-
vehicles and other
vintage
parts. were-
cars and all are being.
It's a sort of museum.
Ah.
So he wanted some protection of
Sort
this
of
court.
museum by this Northeast.
Yes, yes, Lord.
Heritage
yes.
Foundation.
Heritage Foundation. The council, he is no more there. That's why maybe nobody is representing.
Possible. quite
We'll try to inform Lords. We
Sorry.
senior counsel and doctor used to appear in this case. I remember that.
So apart from item 54, other matters are to be decided on the facts of the case.
yes.
Yes,
Is
Lordship.
that not correct?
Absolutely.
And it will require pleadings to be exchanged and
Already exchanged, my lord.
already exchanged.
Different facts are there.
54 में क्या लिखा है? Item number 54.
54 mean to 12 or 8 mean also. You tak পইচা পাতি নিদিলে বাৰু বেলেগ case কৰি তোমাৰ কথা কৈ আছো কত প্ৰতিবাৰে খবৰ নলয়
Yes. Time trade pause is granted. The item number, the PIL number 22/2019 is detached from PIL number 78/2012 and be listed after 2 weeks. This writ petition number 4901/2021 is to be heard by the learned single judge holding the roster full stop. Hence, this writ petition number 4901/2021 and the connected IAs be listed before the appropriate bench.
And I'm just praying for an expeditious disposal because this matter is pending since 2021.
After 10 days,
Okay.
My lord, there is an interim order, it may be extended till the learned single just takes up.
the interim order passed by the passed in these writ petition number 4901/2021 is extended till till the matter is heard by the learned single judge on the next date.
Great.
This item number 57 mein, you are supposed to file, Mr. Sekia.
Lordship will file separate affidavit in item 57.
Item number 57, we also detached from.
57 and 54 similar issues are there.
No, it cannot be similar, Lordship. It cannot be similar.
It's about.
It is a unfortunate incident where the particular tribal people, they left the area and somebody else has enforced.
One incident, it's before the general question is raised. So, and in your matter, you are alleging that on account of that ethnic clashes, they have encroached over your land or whatever it may be, we'll decide it separately. What's the problem in that?
That is correct, Lordship, but the larger issue is the same, Lordship. Basically, the people from the belt and block, they have been displaced.
Decided large issue.
It will be beneficial to him if it is taken by the learned single judge.
Writ petition number 3025/2023, detached from PIL number 78/2012. Mr. Sekia may file response on behalf of the state government in WPC number 3025/2023 within a period of
But let 4 weeks be given to us.
within a period of 4 weeks. Full stop. List after 4 weeks.
State government as well as the BTC authority. Lord.
State government as well as the BTC.
As part of state.
As per it will be listed before the single bench or the
It should go to the single bench, Lordship.
as per roster. Before the learned single judge.
Highly obliged.
56, your lordships have fixed the date before the single judge matter.
After the 10 days.
Grateful.
Item 58.
Mr. Majumdar, leaving aside the core controversy, as of now, the projection is that this CRPC will be replaced and a new
Yes.
Bharatiya
This is another.
Nyaya Sanhita that is going to come in
Yes.
from 1st of July.
First.
So what is the position in that and as
My
far
lord-
as
my lord,
section 24 is concerned?
Keeping that in view, the bunch of documents that I have furnished to your lordships, my lords will find the advertisement that was issued for filling up the posts of the Assam State Prosecution Service.
No, that's fine. We are asking you, what is the position under the new act?
That's what I'm
Section
saying. my lord.
24.
That is what I'm indicating, my lord. Keeping that in view, that new rules are coming into force. This is my instruction, my lord. Keeping that in view, the advertisement also has been kept at halt, my lord. It has been cancelled. Last page of the documents, Lord Mekain.
And sir,
May I submit lordship?
as per our earlier discussion,
My lord.
certainly this whatever you have, what procedure you have followed is not permissible as per the law.
My lord.
So now if we issue a direction,
My lord.
you to follow the procedure laid down under section 24
My
or the whatever the provision which is under this BNSS, new BNSS.
My lord.
So for that purpose, we just want to know that any such provision is there in that new act
Yes.
as equivalent to section 24.
Yes, lordship, it is there, section 18 of the new act.
Section
Have
18
checked,
of the-
lordship.
same.
Verbatim same.
Verbatim same.
If lordship wants, I have a copy. 18, 1 8. Level 80, 45, same. Section 18.
Whenever language to directly to happen.
Section 18, 4 and 5 is similar to 24, 4 and 5.
I'll make an observation that so far as regarding this selection is concerned, this is not in accordance with law, therefore it is set aside and quashed, and in future, the state government shall
Follow section
appoint
24.
as per the procedure laid down under the
24. Possibly more
24,
of
yes,
the
24, now you have also created a separate cadre for
my
that. You have to follow also that.
here. I'm just making one submission. I was thinking, in fact, to bring to the notice of this on court these rules which I have furnished a copy.
Yes.
Lordship, will kindly say possibly this will not come in the way of the directions your
Yeah,
lordship is
this will not
contemplating.
come in as per this section 24(6).
And not only that, my lord, there's one more aspect, my lord. I was thinking whether from the cadre of PP, a person can be brought and appointed as a special PP. Possibly that will not be permissible under the rules. Because if your lordship goes to the second page of the rules, the second page, my lord.
Yeah.
Rule 4 says the following shall be the powers and functions of the members of the service, namely, or so far as public prosecutor is concerned, to give legal advice to the district administration, police, and conduct trials in sessions court. So PP
Section 4.
My lord, say yes, rule 4, this is the rules, my lord. Rule 4, the
The
table
following
under,
shall be the powers and functions of the.
yes.
Yes, yes.
So if the public prosecutor from the cadre of public prosecutor, if a person is to be appointed, he can be appointed only for conducting trials in the sessions court. So this will not cover appointment of a special PP under the POXO code, my lord. Under the POXO Act in the POXO code. So that being the position, possibly your lordship can direct in terms of this Supreme Court judgment to follow section 24. So far as the appointment of special PP is concerned.
We'll simply say that in accordance with law or whatever the law, if you feel that as per section 24 it has to be done or as per these rules it has to be done, we know it in accordance.
And if there is a reference.
Otherwise, it will be speculative directions.
My lord.
We don't have a clear picture.
My lord.
Issues have not arisen, arguments have not been advanced. So may not be
It's not advisable.
advisable
My
to go.
Only thing, Lordship, on the last occasion, the state had made a prayer that till as per the procedure is appointed, the private respondent may be allowed to go. That may not be granted, Lordship.
Why?
Lordship,
Then what remains? So
That is not for our benefit, it's for the benefit of
any public prosecutor,
trials-
Lordship, can for that.
trials should not suffer before the public.
Trials,
That is-
this can be assigned to any public prosecutor.
because Lordship, any accused may take advantage of that also.
They have to be allowed to make stopgap arrangement.
Yeah.
So anybody
I'll
can.
leave it to Lordship.
Will grant them time, stipulated time, until then
Lordship,
this
Lordship.
incumbent shall continue.
My,
Thank you.
obliged.
What is it? CM. Arguments heard. Judgment reserved.
For hearing, item 59.
Further arguments were heard. Judgment reserved. Further.
May I please, your lordship, kindly adjourn the matter for a day?
Item number
59.
59. Where is Mr. KL?
Lordship, he is on legs in court number 13. Much obliged.
After summer vacation.
Much obliged.
Item 62.
The matter is for hearing, but in between we have received a document that is another NIT has come out, Lordship, during the pendency of this matter. And so I would like to place that NIT through an affidavit on record, Lordship.
Item number
62.
62. PIL.
PIL, Lordship, with regard to the flyover, construction of the flyover in Diffu.
After summer vacation.
Lordship, in their affidavit, the KACF also filed a work order where they have given the name of the contractor. Lordship, I believe that it would be better if we could implead them as a respondent.
It's up to you.
Lordship, I'll file them. Obliged, Lordship.
Item 68.
That is your lordship. My lord, this matter pertains to Milord, removal from service Milord for unauthorized absence of 155 days. Or admittedly, Milord, the petitioner at the time of the period, Milord, she was suffering from psychiatric problem. He submitted all the medical documents, my lord. By that time of inquiry, though they exhibited my medical documents, my lord, they have not considered it. But this fact also, my lord, so the single judge also recorded that he admittedly that he was suffering from the psychiatric problem, you know, all this. But instead of Milord taking some lenience, Milord, so the removal, removing from the service by the department, it is appreciated, Milord. Lordship will find that order at observation at page, Milord, single judge 207, Milord.
Just a minute, hold on.
Yes, Milord.
Yes.
So, my lord, in the paragraph 14 of the judgment, single judge judgment, my lord.
Para?
Para 14, 207, my lord.
Yes.
May I read, my lord? All the three charges are in respect of the in absence of his duties on the date mentioned under each head of charge. On the other hand, the medical documents which are available in the pleadings as well as reflected in the records show that the petitioner required treatment under psychiatric department. It is also seen from the inquiry report that medical documents were also taken into consideration. In both the OPD records, there is no medical advice that petitioner is not fit for reporting or to duty. Both these OPD reports render medical advice that petitioner should be given light duty without arms and under supervision. Under such circumstances, it has to be accepted that petitioner was fit for duty, but under supervision and without firearms. From the OPD report, there are two other aspects which are evident, namely, the petitioner has expressed disinterest in work and the petitioner is also on and off alcohol. The charges which are brought against the petitioner specifically with regard to absence neglect from discharging his duties. With regard to the dates mentioned under the above various charges heads, no material is furnished by the petitioner to suggest that he was under conservative medical treatment or that there was medical advice that the petitioner was not found to be fit for duty. Fourth, my lord, in paragraph 14, the single judge recorded that it is seen from the inquiry report, the medical document were also taken into consideration. My lord, and if you take your lordship, the inquiry report at page, my lord, at page 77 and 78, lordship will get that answer, my lord. Page 77 of the inquiry report, my lord.
Yes.
Yes, my lord. In course of inquiry, the charge official adduced the following documents. Number one, my lord, the slip dated 4/5/2019 regards the treatment of the mental stress of the charges official exhibits 15. Number two, my lord, letter dated 18/6/19 of the wife of the charge official to the commandant Chenso praying for the extension of the leave. This is exhibit 16, my lord. And lastly, my lord, slip with regard to the treatment of mental stress of the charges official. This 15, 16, 17. Now observe the findings of the inquiry report on this point, my lord. Lord, you will get it is 78A, my lord. Keeping the principle of natural justice in view of the official was again given the opportunity to defend himself. When asked, the official refused to keep any defense assistant. The official gave his statement and submitted his medical papers and documents in his defense. The official offered a contention that he has been suffering from
Mr. Consul, this 77.
78A, my lord.
But 77 is something different.
77, my lord.
Analysis of the departmental inquiry.
Yes, my lord. Above. Before analysis.
In course of inquiry, charge of.
Yes, my lord. That I read. Yes, three exhibits, my lord. Medical document from my side, my lord. Exhibits 15, 16, 17.
Just. Okay. Slip made with regard to the mental stress, this 4/5/19.
My lord, exhibit 15.
18/6.
My lord.
And slip with regard to.
Exhibit 17.
Mental charge official SCMM.
Yes,
exhibit
my lord.
17.
Yes.
Yes.
This document exhibited from my side. Next, my lord, findings page 78 on this particular document, my lord. Page 78A.
78.
A, my lord. Page number.
78.
A.
A.
A, yes, my lord.
78.
Next page, my lord.
A. Yeah.
Yes.
Keeping.
Yes, my lord, from keeping the principle of natural justice in view, the official was again given the opportunity to defend himself. When asked, the official refused to keep any defense assistant. The official gave his statement and submitted his medical papers and documents in his defense. The official offered contention that he had been suffering from the mental stress and owing to that he could not join his duties on time and remained absent since the time of his leave. In earlier occasion, two official remained absent since the time of his leave. The official pleaded his guilt during the departmental inquiry. Since the official is a member of a discipline force, he has committed a serious offense by remaining absent since the time of his duties. Though they have the 15, 16, 17, but contention of 15, 16, 17, they have not discussed here, my lord. 116, my wife has communicated that I was suffering from mental stress, my lord. It is not discussed, my lord. My wife has informed them that yes, my husband is suffering from this, my lord. Though they have exhibited, but no discussion.
Yes.
So my humble submission, though Learned Single Judge stated that the department has considered all these exhibit documents, my lord, but it admittedly it is not discussed, my lord. And so far as my lord, Learned Single Judge also in paragraph 14 also said that yes, like I am fit for the light duty, my lord. So, my lord, without
Learned Single Judge has come to the conclusion that yes, you were not able to do the hard duties, but light duties, but you have not reported the duty, then to whom give this light duty or hard duty? Where is the question of assigning you any duty?
prior to that leave, my lord, I was in the event 2014 also, I was suffering from psychiatric problem, my lord. Only
It's better to sit at the home and do some light work. Why are you insisting
Yes,
on
my lord.
this
My lord,
discipline force?
my
Because
lord,
it's
after
very
the
hard
incident,
to
my
do
lord,
duties in the BSF.
after the incident, my lord, my mother, my wife, and my daughter, 3 women are dependent on me, my lord. And my lord, they have been
light work.
any light work. They have department is every, my lord, they are instead of removing me from something, have some others punishments also. I'm ready to receive all.
What other punishments are there?
Yes, my lord. In Rule 17 of CRPF, my lord. Lordship, can I, my lord? First, my lord, from dismissal or removal, reduction of rank in fact, my lord, or reduction to a lower stage to time scale pay, or for some other punishment I'm ready to receive.
Another punishment they don't want to keep you in service. What do you mean by other punishment? Reduction in rank, that not this rank and that rank. How it matters?
So let me lord, this person one fair chance may be given to any day if they wish, my lord, one more chance may be given.
Yes, Mr.
My lord, there is no medical advice that he is not fit to join his duty. Already the doctor has recommended that he is fit to join in a light work without arms and under supervision. So that he could have joined on duty. And there are numbers of communication made to the petitioner during that leave period, unauthorized leave period. More than page 54 of the petition, my lord. More than 14 communications were made to him, and he did not respond. So that is what interesting.
No record of the 14 communication things, my lord. Admittedly, I was at the stage, my lord, that period so, my lord, I leave it to your lordship, my lord. Since, my lord, this
leave it to us.
Since, my lord, the removal from service instead of other punishment, I'm ready to receive, my lord, instead of removing me from service. Since my mother, wife, and daughter is admittedly dependent on me, my lord. And since 2000, no service, my lord.
Since 2000?
After removal from service, my lord. Prior to that, I removed me in 2000. Till 2000, I'm still in service.
In order of removal is of 2008.
Argument, sir.
So, yeah.
That's all.